Good afternoon, Southminster scholars. The U.S. Supreme Court has heard thousands of appeals and rendered its verdict. But today, we will join the 9 justices as they do something never done before or since. That is, to listen to closing arguments in a criminal case, and then the Supreme Court determine guilt or innocence. What could have caused the highest court in the land to function as a criminal court? Well, it will involve the rape of a young white woman in Chattanooga in 1906. Sheriff John Shipp led the investigation. A white man named Will Hickson told the sheriff he had seen a black man that evening twirling a leather strap around his finger. Through further reports from Hickson, for which he received a reward from the sheriff, he pointed a finger at Ed Johnson, a black carpenter. Well, that was enough for Sheriff Shipp. Word of Johnson's arrest spread. That evening, a large crowd, many carrying guns, surrounded the jail, demanding Johnson be released for immediate lynching. The next day at the arraignment, Nevada Taylor, the woman raped, hemmed and hawed whether Johnson was the man who attacked her. Finally, she agreed with the sheriff that maybe he was, probably was, could have been. Well, now the stage was set for a quick trial and an even quicker hanging. I'll let Professor Linder lead us through this chain of events that would see the Supreme Court become involved in an actual criminal trial. But as it unfolds, watch for the quick trial in which the jury was split, but then how and why it came with a guilty verdict. Watch for why Johnson's defense attorney would tell the court that Johnson would acquiesce in the verdict rather than appeal it further. Watch for Johnson's resolute insistence he was not the guilty man. Watch for Johnson's father securing a different attorney who promptly filed an appeal. Watch for the rejection by the Tennessee Supreme Court and Johnson's lawyer turning to the federal courts for relief. Watch for Federal District Court Justice Clark agreeing there were serious flaws in Johnson's trial, but declining to overturn the verdict. Watch for the appeal to the Supreme Court and obtaining a delay for Johnson's hanging. But then watch for a Chattanooga mob forcing their way into the jail and lynching Johnson. Sheriff Shipp had not only rejected a request to post extra guards, instead he had let all but one of the night deputies go home, leaving the jail undefended. Watch for the outrage in Washington, with President Teddy Roosevelt ordering a federal investigation to bring criminal contempt charges against Sheriff Shipp. Watch for the results, which exposed Sheriff Shipp and other key players' role in the lynching, let alone the trial. Watch for the one and only time the Supreme Court would actually try a conspiracy to commit murder itself. Watch for the courts appointing a deputy clerk to preside over the trial itself, to ascertain the facts for the justices to review, and then the justices decide guilt or innocence. Watch for the trial then moving to the 9-man Supreme Court, where Sheriff Shipp and 5 others were found guilty of criminal conspiracy and contempt, and the fines and prison terms that were levied. But finally, watch for the outcome and the reaction in Chattanooga.
It's March of 1909 in Washington, D.C. The 9 justices of the Supreme Court assembled to do something they have never done before and never will do again. In fact, what the justices are about to do has never been done before by any Supreme Court before or since. They are about to listen to closing arguments in a criminal case. What terrible crime might the defendants have committed to be brought before the nation's highest tribunal? Well, to answer that question, we have to go back to a winter evening 3 years earlier, January 23rd, 1906. On that evening, a beautiful 21-year-old named Nevada Taylor left her bookkeeping job in downtown Chattanooga about 6 p.m. It was January, and darkness came early. She boarded a trolley for the 20-minute ride to the station near the base of Lookout Mountain. Taylor exited the trolley. She began her short walk to her home, a cottage in Forest Hills Cemetery, where her father was a groundskeeper. As she approached the cemetery gate, she felt her throat grab from behind. A voice said, "If you scream, I will kill you." The attack, which left Taylor raped and unconscious, lasted only 10 minutes. Sheriff Joseph Shipp led the investigation into the rape. He asked Taylor what she remembered of the attack. Not much, it turned out. Taylor described her attacker as muscular, wearing a black outfit and a hat, and having a soft, kind voice. She told the sheriff she wasn't sure of her attacker's race, but thought he might have been an African American. An investigation of the crime scene turned up a black leather strap that matched the red streaks around Taylor's neck. Word of the find prompted a man who worked near the rape scene, Will Hickson, to report that he had seen a black man twirling a leather strap around his finger on the evening of the rape. Hickson called Sheriff Joseph Shipp. He told him that he had just seen the suspect walking toward town with a tall black man. Shipp hurried off. He found the tall African American alone, but learned that the man's companion was a part-time carpenter named Ed Johnson. Within hours, Shipp spotted Johnson riding on the back of an ice wagon. Johnson was handcuffed and jailed. Hickson identified him as the man he had seen twirling that leather strap. Hickson pocketed a $375 reward for identifying Nevada Taylor's attacker. Word of Johnson's arrest spread. That evening, a large crowd, many carrying guns, gathered in front of the Hamilton County Jail. Some members of the mob fired into the sky. It took the National Guard to fend off the lynch mob. But Johnson was not in danger, at least not that night. Anticipating problems, authorities had moved him to a jail in Nashville. Nevada Taylor traveled to Nashville to identify her attacker. She hemmed and hawed, expressed doubts, but in the end she said she was fairly sure that Johnson was the man who had raped her. Taylor's identification put the case on a fast track. A Chattanooga judge told grand jurors that outrages such as this must have the immediate attention of the law. 2 hours later, a grand jury indicted Johnson. The judge quickly appointed 3 local attorneys to represent Johnson and told them to get moving. The trial would begin in less than a week. The first prosecution witness in the Johnson trial was Nevada Taylor. Taylor described the attack and identified the leather strap used by her assailant. The prosecutor asked Taylor if the man who attacked her was present in the courtroom. "I believe he is the man," answered Taylor, pointing to Ed Johnson. When Will Hickson was called to the stand, he told jurors that he saw the defendant with a strap in his hand near the scene of the crime. Hickson claimed Johnson's face was illuminated by 2 electric cars passing by Cemetery Station. "I saw his face well and could not be mistaken about it." Sheriff Shipp testified next, recounting his investigation and the events leading to Johnson's arrest. Shipp said that at the sheriff's office in Nashville, Johnson raised his voice to a higher pitch in an attempt to prevent Taylor from identifying his voice as that of the attacker. 2 of Shipp's deputies offered brief testimony and then the case was rested. It was a very superficial case. It relied almost exclusively on eyewitness testimony, the perfect recipe for a wrongful conviction. The first witness for the defense was Ed Johnson. Johnson spoke in what observers called a strange voice. Nervous, he grasped the arms of the witness chair with his hands. He denied having attacked Nevada Taylor. Johnson testified that, in fact, he spent the entire evening in question working as a pool room porter at the Last Chance Saloon. He said he arrived around 4:30 and stayed until about 10 o'clock at night. He couldn't have possibly raped Nevada Taylor at 6 o'clock. 13 witnesses followed Johnson to the stand. Each one swore that he had seen Johnson at the Last Chance Saloon working during the time Johnson claimed he was there. The defense moved on to attack the credibility of Will Hickson. One defense witness testified that 2 days after the rape, Will Hickson had asked him the name of a black man doing some roofing work at a church. When he told Hickson the roofer's name was Ed Johnson, Hickson asked for a physical description. Odd, don't you think, for an eyewitness to ask for a physical description of the person he would identify to police as the suspect? The most dramatic event of the Johnson trial occurred on its third and last day. At the request of jurors, Nevada Taylor was recalled to the witness stand. During the questioning, a juror in the jury box rose and asked, "Miss Taylor, can you state positively that this Negro is the one who assaulted you?" Taylor answered, "I will not swear he is the man, but I believe he is the Negro who assaulted me." The juror wasn't satisfied. He asked again, "In God's name, Miss Taylor, tell us positively, is that the guilty Negro? Can you say it? Can you swear it?" Tears streamed down Taylor's face. She answered in a quivering voice, "Listen to me. I would not take the life of an innocent man, but before God, I believe he is the guilty Negro." At that point, a second juror rose from his seat and lunged at Ed Johnson. The would-be assault was thwarted by fellow jurors, who grabbed him. The angry juror shouted out, "If I could get at him, I'd tear his heart out right now." The jury deliberated the fate of Ed Johnson for over 6 hours and was still split, 8 for conviction and 4 for acquittal. After a night at home with their families, the minority caved in. The next morning, the jurors' foreman announced, "On the single count of rape, we, the jury, find the defendant, Ed Johnson, guilty." Then, after a recess, came a shocking announcement from Johnson's defense attorney. He told the judge that the defense would acquiesce in the action of the jury. Now, why would defense attorneys counsel a client to accept a wrongful sentence of death? 2 of Johnson's 3 defense attorneys believed an appeal to be futile. Moreover, they worried that an appeal might lead to a raid on the jail that would result not only in Johnson's death, but the death of other inmates as well. So the attorneys told Johnson he had a choice. He could accept the verdict and die in an orderly way at an appointed time, or he could die at the hands of the lynch mob. Johnson agreed not to appeal. "I will tell the judge I am ready to die, but I will also say that I am not the guilty man." But Ed had second thoughts. Hours after the death sentence was pronounced, Ed Johnson's father, known as Skinbone Johnson, visited the law office of Chattanooga's most highly respected African-American attorney, Noah Pardon. Skinbone told Pardon that his son did not want to die. He had changed his mind. He wanted to appeal. Now, Pardon was reluctant to take the case, although Johnson may well have been denied a fair trial. Convincing the Tennessee Supreme Court to grant a new trial in an emotionally charged case such as this would be next to impossible. But Pardon's law partner, Stiles Hutchins, thought differently. It is a lawyer's job to seek justice, regardless of the odds or the cost. Pardon and Hutchins took the case. In a decision that surprised no one, the Tennessee Supreme Court, without a dissenting vote, turned down Johnson's request for a new trial. Sheriff Shipp ordered his deputies to begin stretching the rope that would be used to hang Johnson in 10 days. But Noah Pardon did not give up. He took the battle to save Ed Johnson to the federal courts. 6 days before the scheduled execution, Pardon traveled by train to Knoxville to file a petition for a writ of habeas corpus in federal district court. Now, there's little reason to expect relief in the federal courts. Federal judges could not review the evidence presented in state trials. They could only act to remedy violations of federal constitutional rights. And in 1906, the defendants had very few of those. The Supreme Court had narrowly interpreted the 14th Amendment's Due Process Clause and the protections of the Bill of Rights, the right to an impartial jury, to an effective counsel, the right against self-incrimination. None of these had yet been found to apply in state trials. In fact, as of 1906, there existed not a single case in which the federal courts had reversed a state court conviction on the basis of the Due Process Clause. Pardon argued before a federal judge, C.D. Clark, that Johnson's trial was riddled with constitutional violations. He contended that the trial judge's refusal to delay or move the trial, in view of the attempted lynching and other threats, denied Johnson due process. He said the same thing about the jurors' tear his heart out lunge at Johnson. He argued that the county's systematic exclusion of black jurors violated the Equal Protection Clause. Finally, Pardon suggested that Johnson had been abandoned by his court-appointed attorneys after the trial, like a lamb being led to the slaughter. After listening to arguments, the judge agreed that there were serious flaws in Johnson's trial, but he ruled that the guarantee of a fair trial did not apply in state trials. In a small victory for the defense, however, Clark postponed the hanging for a week to allow time for his decision to be appealed to the Supreme Court of the United States. Meanwhile, the efforts of lawyers Pardon and Hutchins had not gone unnoticed. In the early morning hours of March 15th, an unidentified person set fire to their wood-framed law office. The blaze was extinguished, fortunately without major damage. Later that afternoon, Pardon left Chattanooga by train for Washington to make his final plea to save Ed Johnson's life. On the morning of March 17th, Pardon and a Washington lawyer named Emanuel Hewlett entered the waiting room of the Supreme Court in the old Senate chamber. The wait seemed interminable. Pardon began to despair. Finally, however, the court's receptionist appeared at the doorway and announced, "He will see you now." But he turned out to be Justice John Marshall Harlan. Now, Harlan was the same justice who, observing that the Constitution is colorblind, dissented in Plessy versus Ferguson, the famous case which upheld the principle of separate but equal. Harlan asked Johnson's lawyers, "Mr. Pardon, Mr. Hewlett, tell me why the United States Supreme Court should care about this case." The two lawyers proceeded to do so. The elderly justice nodded without giving them a word of encouragement. While his client's execution was now just 2 days away, Noah Pardon arrived back at the Chattanooga train station. On the platform, he saw his overjoyed law partner waving a piece of paper in the air. It was a telegram from Washington signed by Justice John Harlan. "Have allowed appeal to accused in habeas corpus case of Ed Johnson." In the hours after his meeting with Pardon, Harlan had read the transcript of the Knoxville hearing and became convinced that Johnson's case raised serious constitutional issues. At Harlan's request, a majority of justices gathered on Sunday morning in the home of Chief Justice Melville Fuller to discuss this plea for intervention. After debating the issue for an hour, the justice agreed to take the unprecedented action of staying the execution and granting Johnson's appeal. Telegrams were sent to the judges, the defense lawyers, prosecutors, and Sheriff Shipp, informing them of the Supreme Court's action. Now, the news that the Supreme Court had stayed Johnson's execution did not sit well with many in Chattanooga. About 8 p.m. on March 19th, a group of men carrying guns descended on the jail where Johnson was held. That night, only a single guard was assigned to the jail. Sheriff Shipp, rejecting a suggestion to post extra guards, instead gave all but one of the deputies the night off. The mob poured into the jail and began looking for their prey. Confronting a large steel door, members of the mob called for a sledgehammer and whacked it in turn. The door finally gave way and the mob pushed in. Ed Johnson on the third floor was awakened by the cries of inmates below. He looked out the window of his cell and saw a crowd of nearly 200 men and women in the courtyard below. The only other inmate on the floor, Ellen Baker, said to Johnson, "You better do some praying." The mob soon made its way up the spiral staircase to the third floor and pounded on the doors that still separated them from Johnson. A second door was comprised of steel bars secured by 5 bolts riveted into the cement floor. It proved a frustrating obstacle for the lynchers. Johnson had plenty of time to pray. Ellen Baker later described Johnson lying on his steel-framed bunk, a green wool blanket pulled up to his chins, eyes closed, reciting the 23rd Psalm. After 2 hours, the last bolt gave way. Mob members tied Johnson's hands with rope and dragged him from the cell to the awaiting crowd. Cries of "Kill him now" and "Cut his heart out right here" rose from the mob as the leaders of the mob debated what to do. Finally, someone yelled, "To the county bridge!" The call was met by great applause. The crowd marched the 6 blocks to the Walnut Street Bridge that crossed the Tennessee River. At the second bridge span, a mob member looped rope around the frame of the bridge. A man holding the noose asked Johnson, "Do you have anything to say?" With the noose around his neck and blood dripping from his mouth, Johnson remained calm. He spoke to the crowd. "I'm ready to die, but I have never done it. I'm going to tell the truth. I am not guilty. I have said all the time that I did not do it, and it's true. I was not there. God bless you all. I am innocent." For 2 minutes, Ed Johnson's body jerked with life as it swayed 100 feet above the Tennessee River. Then the movement stopped, and Johnson was pulled back up to the bridge. When his head moved, a barrage of bullets ended his life. A leader of the mob pinned a sheet of paper to Johnson's body. The note read, "To Justice Harlan, come and get your now." When word of Johnson's lynching reached Washington, Justice Harlan and Justice Oliver Wendell Holmes asked for a meeting with Chief Justice Fuller. Afterwards, each justice expressed his outrage to the press. Justice Harlan told a reporter for the Washington Post, "Johnson had the right to a fair trial, and the mandate of the Supreme Court has, for the first time in the history of this country, been openly defied by a community." Holmes was equally angry. In all likelihood, this was a case of an innocent man improperly branded a guilty brute and condemned to die from the start. President Theodore Roosevelt announced, "It is an affront to the highest tribunal in the land that cannot go by without proper action being taken." President Roosevelt, after meeting with Attorney General William Moody, ordered a federal investigation of the lynching. Less than 2 days after the lynching, 2 Secret Service agents were on their way to Chattanooga to begin gathering evidence. The agents discovered that most lips in Tennessee were firmly sealed. Walking back to the hotel after an unproductive day of investigating, the agents were confronted by 3 pipe-wielding men who warned them to leave town. But eventually the agents, with the assistance of Noah Pardon, identified witnesses who could shed light on the events surrounding the lynching. The agent's report detailed unusual activities in the jail prior to the lynching. It also described the actions of key players in the conspiracy, including Sheriff Shipp. After the report was filed, Attorney General Moody met with Chief Justice Fuller and Justice Harlan. They reached an historic and unprecedented decision to try the conspirators in the Supreme Court for criminal contempt. The Attorney General filed criminal charges with the clerk of the Supreme Court, and the Justice Department led the prosecution. Attorney General Moody charged 27 Chattanooga residents with conspiring to lynch and murder Ed Johnson in violation of the court's stay. Included among the 27 were Sheriff Joseph Shipp and 8 of his deputies. The defendants and their lawyers assembled in a courtroom on the second floor of the Capitol building, where the Supreme Court met at this time. After the justices took their seats on the bench, the Solicitor General announced that the federal government was ready to proceed with the case of United States versus Shipp. Each of the accused stepped forward to enter their pleas of not guilty. The defense argued the Supreme Court had no power to try a criminal case, but the court, in a unanimous decision written by Oliver Wendell Holmes, ruled that it did. The 9 justices, however, announced that they would not themselves listen to the actual witnesses in the trial. Having no time to do that, they appointed James Mayer, Deputy Clerk of the Supreme Court, to preside at the trial and prepare an evidentiary record which the justices would review. The trial opened in February 1907 in the United States Custom House in Chattanooga. The courtroom was filled to capacity, mostly by African Americans, as Mayer took his seat on the bench. The first prosecution witness was a reporter for the Chattanooga Times who witnessed and wrote about Johnson's lynching. The reporter testified there were normally 6 or 7 deputies on guard every night at the jail, except on the night of this lynching. Jailed inmate Ellen Baker testified that all the other third-floor prisoners were removed to the lower floors on the afternoon of the lynching, leaving just her and Johnson on the 3rd floor. Baker said that she began crying and shouting as the mob made its way through the jail. Deputy Gibson, the lone guard at the time, told me to hush hollering. There weren't nobody going to hurt me. A key witness for the prosecution was John Stonecipher, a Georgia man who talked with leaders of the mob at the saloon just hours before the lynching. Stonecipher testified that a man named Frank Ward asked him to participate in the lynching. Stonecipher replied he wasn't interested and warned, "I believe Sheriff Shipp would shoot the red-hot stuff out of you." "No," Ward answered. "It is all agreed. There won't be a sheriff or a deputy there." Stonecipher also testified concerning conversations he had after the lynching with several of the defendants. For Stonecipher, testifying took guts. After he agreed to testify for the prosecution, he received an anonymous letter from the lynchers threatening to blow up his house with dynamite. A Chattanooga Justice of the Peace, A.J. Ware, testified about the actual lynching. Ware had followed the lynch mob to the Walnut Street Bridge. Asked by the Assistant Attorney General who he saw put the noose around Ed Johnson's neck, Ware replied, "Nick Nolan." Asked who shot Johnson after he was pulled back up to the bridge, Ware answered, "I believe it was Luther Williams. He fired 5 shots into Johnson's body." The defense based its case on friends, relatives, and co-workers who offered alibis or attested to the high moral character of various defendants. Some of the defendants themselves also testified. Bart Justice claimed he spent the night of Johnson's lynching at home in bed, and his wife and daughter backed him up. One defendant, Luther Williams, admitted to being present at the lynching, but he claimed just to have been a spectator. Sheriff Joseph Shipp was the last witness called by the defense. Shipp said, "I never conspired with any living man. My deputies, or anyone else, I had no knowledge, not the slightest, that there would be any effort on my part or anybody to interfere with Johnson. Shipp claimed to have run most of the way and walked rapidly the balance of the way to the jail as soon as he learned that a lynching was in progress. At the jail, Shipp told the court, "I was seized from behind by several men. They stood over me with a guard as the mob leaders continued the progress of their work." On cross-examination, Shipp claimed not to have recognized any of the mob members at the jail, even though he was held there without blindfolds for 30 minutes. Asked why he didn't pull out his gun to stop the lynching, Shipp replied, "I knew that the pulling out of a gun would be useless." The defense rested. Then more than a year passed before the trial is finally moved to the Supreme Court in Washington. There, both sides presented closing arguments. Attorney General Charles Bonaparte delivered a 6-hour final argument. Bonaparte told the court, "Justice is at an end when orders of the highest and most powerful court in the land are set at naught." The closing argument for Sheriff Shipp came the following day. Shipp's defense attorney conceded that his client did not handle the situation properly. It is possible that Captain Shipp acted with poor judgment on the night of the lynching. It is easy to see that he should have guarded the jail and prepared for a mob. But, Harmon argued, Captain Shipp cannot be convicted of contempt by this court simply because, in the performance of his duties, he had exercised bad judgment. He concluded by urging this highest and greatest court in the world to find Shipp, this truthful, law-abiding, honorable gentleman, not guilty. The Supreme Court announced its decision in May of 1909. Chief Justice Fuller read the opinion. Sheriff Shipp, he said, resented the order of this court as an alien intrusion. So Shipp not only made the work of the mob easy, but in effect aided and abetted it. Shipp is guilty of criminal contempt. The court also declared jailer Jeremiah Gibson and 4 members of the lynch mob guilty. Evidence was found insufficient to convict the other defendants. Justices Holmes, Harlan, Brewer, and Day joined Chief Justice Fuller's decision. 1 justice abstained, while 3 dissenting justices voted to acquit all the defendants. On November 15, 1909, Sheriff Shipp and the other convicted defendants stood before the 9 justices of the Supreme Court to receive their sentences. Justice Fuller read the sentence. You, Sheriff Joseph F. Shipp, Jeremiah Gibson, Luther Williams, Nick Nolan, Henry Paget, and William Mays, are before this court on an attachment for contempt. You have been found guilty. Sheriff Shipp, Luther Williams, and Nick Nolan are hereby sentenced to 90 days imprisonment. Jeremiah Gibson, Henry Paget, and William Mays are hereby sentenced to 60 days. All sentences are to be served at the United States Jail in the District of Columbia. This court is adjourned. Writing in the Atlanta Independent, Noah Pardon praised the court's decision. The very rule of law upon which this country was founded and on which the future of this nation rests has been enforced with the might of our highest tribunal. Would-be lynchers might now think twice before acting. After the Shipp decision, the South saw a steady 5-year decline in the lynchings of black citizens. But if the Shipp decision reduced lynchings, the effect was only temporary. By 1919, there were more lynchings of African Americans than there were the year Ed Johnson faced his killers on the Walnut Street Bridge. Johnson's death mooted the arguments in his own case, which might well have become a landmark Supreme Court decision. But the legal arguments raised by Noah Pardon and Stiles Hutchins in their appeal have, almost all, now become the law of the land. After serving his 3-month sentence for criminal contempt, Sheriff Shipp returned to Chattanooga. He received a hero's welcome. As he stepped off the train from Washington, he was welcomed by a crowd of more than 10,000 people singing Dixie. Shipp raised his hat and bowed to the right and left. Noah Pardon and Stiles Hutchins never returned home to Tennessee. They lectured about their case in northern states, then settled in the Oklahoma Territory. Neither man ever practiced law again. In their book about the Shipp case, Mark Curran and Leroy Phillips point out that there is no statue or memorial in Chattanooga honoring the courage of these two men. History has forgotten them. Curran and Phillips argue, and who could disagree, that they deserve better. They were heroes.
A few takeaways for me. Did you catch the note the mob leader pinned on Johnson's body after lynching? To Justice Harlan, come and get your nigger now. I'm not surprised that Teddy Roosevelt was outraged. Not so clear is why the Supreme Court decided to get involved in the first place. This was the same court that had not long ago decided separate but equal was constitutional, even though it was clear it was highly unequal. But I'm glad they did. Perhaps one of the learnings here is that there is some room in the law for equity, fairness, truth, and actual justice, and that judiciary can become outraged by flagrant abuses and certainly flaunting its authority. Lawyers are often the butt of jokes. On the one hand, on the other hand, able to argue any position they are hired to champion. But beyond that, most lawyers I know take very seriously their oath as officers of the court to seek justice. And perhaps that's one of the learnings from the Shipp trial, that there are lawyers and judges willing to stand up for justice, even when it will make them unpopular to the point of death threats, loss of stature, and loss of business. Fortunately, there were such heroes in this case who became the voice of Ed Johnson's innocence when he could no longer speak. Well, comments, observations, if you have any, run me down, give me a call, comment on QB. Next week, a famous trial in which the defendants were clearly guilty. They admitted they were, but were defended by Clarence Darrow in an effort to avoid the death penalty which he abhorred. This will be the Loeb and Leopold trial in Chicago in 1924. And as always, thanks for coming.